Good afternoon. This is Dave Henry. We're talking about what smart lawyers know, building and maintaining clients through mediation. If you've signed up for this, I thank you, and I commend you for picking what may be or may seem on its face a little bit of an unusual topic. I am very passionate about mediation. I was a civil litigator for 30 years. I now am a full-time mediator here in Orlando. And before I became a mediator, though, I had the pleasure of being able to litigate across the country. So I saw mediation in a variety of different places, from California to South Carolina to Illinois and Alabama. So I've seen how mediation goes down. And the thing that struck me when I was doing this was it was the only time when I had a large block of time with my clients. The clients would be with me for 4, 5, 6, 8 hours. And if you think about it as a litigator, you don't really get that opportunity. I mean, almost no lawyer gets that kind of access to a client where the client's focused on one problem, the case, trying to get the case resolved, and you're there together, sort of in a cocoon, sort of in a cloistered setting, the mediation process. And so it struck me that that's an excellent opportunity for you to develop and build a client relationship. You're not going to get that opportunity in really any other way. You're not going to get it during a deposition because your client's going to be, under duress in the deposition. And here you're just worried about one problem, and that kind of focus and that kind of unique setting really is pretty valuable. I don't think I really got that till much later in my life. The client's going to be examining, scrutinizing your conduct in the mediation process and comparing you to the other mediators who are operating in that, other lawyers who are operating in that arena. And if they're institutional purchasers of insurance services, they're a carrier, they're a large organization that buys lots of lawyers, they're going to compare you to other lawyers that have mediated cases for them. So when you start thinking about it, it's really a very important time in the life of your relationship where you can solidify that client relationship and improve upon that client relationship in a way that the other aspects of litigation are not going to let you do that. I mean, when they're working with you on discovery problems or working with you on trial prep, that's a pretty rare event, right? Trial prep's pretty rare event. So mediation is the thing that you need to be good at because it's the thing you're going to do in almost every civil case. Many jurisdictions have mandatory mediation. The ones that don't eventually will probably get there. There's a sort of a discrepancy or a disparity in the way mediation is handled across the country. Like where I'm from, Florida, all the cases go to mediation in state and federal court. You go to other states like maybe Ohio or someplace like that, it might be voluntary. It wouldn't necessarily be court ordered. And so the degree to which people participate in mediation might vary a little bit, but the trend is upward. The trend is toward more and more mediation. So I want to spend a little time thinking about mediation at 30,000 feet because I think it's hugely valuable. I mean, if you think about it, it's probably the least appreciated aspect of the civil justice system. It's not well appreciated because mediation occurs in a cloistered setting. It's a confidential privileged proceeding. Nobody knows what went on there except the people who participated. There aren't any summaries, there aren't any recordings, there aren't any transcripts. So it doesn't have any of the sort of public spectacle that a trial has or even the evidentiary hearing has. It doesn't, it can't, it doesn't work that way. And so it's not surprising that the public doesn't necessarily appreciate how valuable and important mediation is in the process because there's no public way for them to access it unless they're actually a participant. It also means it's sort of hard for us to get good at mediation because we don't have the normal didactic tools available to us. If you're a young lawyer and you're going to be a litigator, you can watch what other people do. You can sort of mimic that behavior. Most young lawyers, what we do is we mimic, right? We model other behavior that we've seen. We use other motions as forms. We copy discovery forms. We mimic behavior during depositions. We mimic how other lawyers more senior do something, and we sort of copy that. We replicate. Well, mediation doesn't necessarily give you that kind of opportunity because there isn't any transcript, there isn't any writing, there isn't any recording. There's not even a written opinion. So there's no teachable moments except what you yourself witnessed during the mediation process. And so we got to spend a little bit more time talking about what's happening in mediation and what we got to do to prepare effectively for mediation. Because I think there's a lot of ineffective, not so great preparation for mediation. I spent a lot of time talking to law firms and bar organizations about ramping up for mediation, because a lot of times mediation's impasse for reasons that could have been avoided because there was inadequate prep. And one of the reasons there's inadequate prep is because there aren't any rules. I mean, the funny thing about mediation is it's the least lawyerly thing that we do, but it's arguably the most important thing we do. You don't have to use the skills of a lawyer, application of fact to law, navigating procedural and substantive rules, dismantling experts, handling witnesses on the stand. None of that is any value in mediation. It has no value. And so you have to realize that mediation, I say, turns on a different axis than trial. It's not a break from the trial process. It operates on a completely different axis. It has nothing to do with trial or trial practice. It has to do with the art of deal making and dealing with difficult actors. And unfortunately, we don't learn very much about that when you're in law school. We learn the sort of normal lawyerly things that they've been teaching for decades and decades. And the law school education hasn't really evolved all that much over the last couple hundred years, unfortunately. So we're going to spend some time talking about how to get good at mediation, because being a good trial lawyer is not enough. I see these law firms advertising themselves, and they put all this stuff on their website about what great trial results they have and how they're really strong advocates and they can, go to the mat for their clients. Clients don't want to go to trial. No client really wants to go to trial. They're not interested in that. They're interested in resolution. And mediation gets them resolution with very little pain and very little expense. I mean, if you think about mediation compared to trial, well, trial practice has got motion practice, discovery, all kinds of, judicial machinery provided by the government, your staff, all sorts of things the client's got to do, the lawyer has to do. I mean, it's incredibly laborious to prosecute a case or defend a case, right? It takes months and years and tens of thousands or hundreds of thousands of dollars. That's door number one. Door number two, mediation. Well, all we do is get everybody together in a room with a pot of coffee, and a few hours later, out comes a settlement. Now, the simplicity of that, the elegance of that, the cost effectiveness of that should make your head explode. So it's so amazingly better than trial practice. My dad wasn't a lawyer. He was an executive at a government contractor defense firm in Florida, and he wasn't a lawyer, but he had to hire lawyers from time to time. And he said to me, he said, David, he says, litigation is like banging your head against the wall. It feels so good when you stop. And I always remembered that because he's right. Trials aren't, and we're not going to get more trials, by the way. No one's predicting an increase in trials. Right now, we try about 1% of our cases. About 1%. That's all. It doesn't matter what state you're in, what county you're in. It's 1.5%. So the market has spoken. The market has shorted trial. I mean, markets don't like this. The marketplace of dispute resolution has said trials are no good. The defense bar doesn't like it. The plaintiff's bar doesn't like it. If one side of that equation, the plaintiff or the defense bar, liked trials, you'd have more of them, right? Because you got to have two people to make a deal. But trials are not increasing. Trials are not going to go up. They've been stable at 1.5% now for several years, and no one's predicting it's going to increase because they're too expensive. There's too much risk. It takes too much time for all the obvious reasons. So mediation's a growth stock. Mediation's here to stay. More and more jurisdictions are going to start mandating mediation because the smart jurisdictions know that. That's a good way of managing crowded case dockets, is to get the cases out of the system. And most jurisdictions that have mandatory mediation report settlement rates in the range of 60, 70, 80%, depending on the type of case. That's pretty good odds, right? I mean, you show up at mediation in Florida, you got about a 75% chance of settling your case the first time around. And if you go to a second mediation, you've got another 20% chance of settling the case because only 1 or 2% are going to trial. So we know the overwhelming majority of the cases are going to settle at mediation or soon thereafter. And so why we as lawyers need to get really good at this. But it's not enough to be good at trial practice. You're only going to do that 1% of the time. You got to get good at the thing you're going to do 95, 96% of the time. I think that's really important. I think it's really important. And the clients are going to appreciate your skill and advocacy in getting resolution. They're looking for a problem solver. They're not looking for a gut-busting 2-week trial in federal district court. They don't want that. They want you to solve their problem, and mediation is one whale of a good tool for helping them get their problem resolved. All right. If we're going to mediate, let's talk just real quickly about one important distinction. There are private mediators, and in some jurisdictions, you're going to get a magistrate, particularly if you're in federal court. Some states do it too. So they'll give you a magistrate judge who is not the presiding judge in the case, who will be the mediator, and they'll give you a couple hours or something like that. When I'm talking about mediation, I'm talking about ordinary civil mediation with a private mediator that the parties have retained of their own choosing, paid by the hour for their services. If you're using a court-appointed magistrate, or essentially a judge, to mediate your case, that's kind of a different animal than what I'm dealing with. I mean, it's similar, but I don't recommend we use magistrates, and we'll talk more about that later on. The mediations that I'm talking about are conducted by private mediators. And if you're not in the habit of using private mediators, you probably should be. All right, let's talk a little bit about improving the art of mediation advocacy. There's a problem with the incentives. Our incentive systems is out of whack because trial lawyers get paid to litigate cases. They don't get paid to settlement. I haven't seen any institutional clients, insurance carriers, others who provide a settlement bonus. I always thought that might be a good idea, but nobody does that. So you render yourself unemployed. You're doing the most altruistic thing you can do when you settle the case, because you're rendering yourself essentially unemployed. And that's what you're supposed to do. I don't think we spend enough time talking about mediation because it's not value affirming. It doesn't build your careers or reputations. They don't have buildings or statutes of great mediators. Or if I said to you in your hometown where you're listening from, who are the good mediation advocates? You'd scratch your head and you'd do one of these. You wouldn't know. You probably wouldn't know who to name. If I told you who are the best trial lawyers in your town, oh, you could name me. You could rattle off some names of people who are held in high regard in that respect. But because mediation is cloistered and confidential, we don't have that. We should, but we don't. The system's kind of backwards that way. 95% of the cases settle, right, before trial. There's a small percentage that go away by dispositive motion, but the overwhelming majority of them settle. But we don't really celebrate settlements. We don't talk about settlement or mediation advocacy. We just don't do it. It's a funny problem, isn't it? It's kind of a funny problem. But it's this opportunity for uninterrupted client engagement that I need you to appreciate, that I hope you'll think is worthwhile. Let's talk about quickly who you pick as a mediator. Kind of a little counterintuitive there. You want the mediator that the other side is comfortable with. Sponsorship theory says you want the mediator the other side wants, because you want them to carry the message, and that has to be accepted by the other side. So if I'm a defendant and I give you my last number and I say that's all I've got to sell the mediator on that concept. That's all I got. And then the mediator has to sell that in the other room. If that mediator is trusted by the plaintiffs and plaintiff's attorney, then they can sell that message effectively. So it's a little counterintuitive. You don't want the mediator you want the mediator that the other side wants. And so what we typically do is say, hey, if I'm a defendant, plaintiff, give me 3 mediators that you like, and I'll pick one of those. And I'll almost always defer. If I'm a defendant, I'll almost always defer to the plaintiff's choice, and vice versa. 95% of my career I did defense of some form, intellectual property, E&O, D&O, products, aviation. So most of what I did was on the defense side in one shape or form or another. Talk about timing for a little bit. One of my big frustrations with lawyers is that they wait too long to mediate. They come to me as the mediator and they've pumped $100,000, $150,000 into the case. The case is only going to settle for a couple $100,000, and now they're upside down on this thing. They're upside. They got more money in the case than the case is worth. And so it's very difficult to create a settlement like that when you got these sunk costs. So I always urge you to have an early mediation and a late mediation. You say, well, why would you have 2, David? Why wouldn't you? See, this is one of the funny things about mediation, because there are no rules. Most of what we do in mediation is habit and custom. It's just habit. It's just unexamined habit and ritual behavior. because there aren't any rules. The only rule of mediation is confidential and privileged. Other than that, really aren't any other rules. So how do you know if what you're doing leading up to mediation, during mediation, is the right way, the best way to do it? What are you doing to optimize the mediation process so that you give yourself the best chance of settling the case, right? Well, one of the ways what I see is behaviors are not optimal. They're suboptimal behaviors. Not bringing the right person to mediation, waiting too late in the life of the case when the sunk costs are too high, not getting all the necessary parties, joining parties too late, and then they're not up to speed, and then throwing them into a mediation before they've had a chance to get their arms around the dispute. There's any number of ways that you engage in behaviors that are either helping the mediation process or potentially harming the mediation process. In other words, that behaviors that are more cause you to be more likely to settle the case, or behaviors that are going to cause you to be less likely, impediments to settlement, or to hamper the process. Lawyers are hesitant to engage in early mediation because they don't like unknowns. They don't like doubt. They don't like uncertainty. They want to have confidence. They want to have all the information and all the data and all the information, the expert testimony and all the discovery. So they think that because that way they can handicap the exposure. They think they're better at handicapping the exposure. The problem is you spend a lot of time and money and you create a lot of animosity along the way, because as litigation festers, as it lingers, parties become more polarized, not less. And so it's harder sometimes to craft a deal when you've been slogging through the litigation for months and months or even years at a time. Then you come to me after 2 years of litigation, $500,000 in legal spend, and you tell me you want to come up with an option. Well, the options are a hell of a lot more limited 2 years down the road. And so what I did in my career, at the end of my career, when I started figuring all this out and all the pieces started to align, is I always told the lawyer on the other side, hey, we're going to have 2 mediations. One, 90, 120 days after we get involved in the case, and then one later in the litigation process, because invariably, if we mediate early and we're not successful, that's fine. We'll have another mediation down the road. But by scheduling 2 mediations, the benefit is neither one of us has to ask for it, because you don't want to be the lawyer that asks for a second mediation late in the life of the case, because it could be interpreted as a tell. But if we agree at the beginning we're going to have 2 mediations, nobody has to ask for it, then there's no tell. And invariably, one of us or both of us are going to want that second mediation. And so planning 2 mediations in the life of the case is so simple. It's so easy. You don't schedule it early on, so you're not, scrambling on the eve of trial when a bunch of deadlines are coming up and trying to shoehorn in a mediation. Then don't do that. Get your mediation date set up months in advance so you don't have the last minute hassle. Everybody knows that date's out there. They got their hotel, their reservations, or it's just a Zoom call. They got it locked off, a lot of book, held on their calendar. So much simpler. But that's one of those things that I chide the courts because they don't do it. Every circuit judge or every district judge I talk to, I say, why don't you mandate 2 mediations? I mean, it's not that expensive to go to a second day of mediation. It's the cost of, no more expensive than having a deposition or engaging in a motion practice, or drafting a motion to compel is as expensive as going to mediation. So why wouldn't we just have another mediation? The mediation fee is trivial compared to what you're spending in all other aspects of the case, right? So set 2 mediations. Think carefully about the timing. You gotta have enough time so you get the 4 corners of the dispute, you get your arms around the problem, but not so much time that you've now created a lot of hassles and impediments and sunk costs, et cetera. Most mediations occur too late because by custom. This is one of those many things that occurs by custom. When the courts started mandating mediation back in the 1980s, and I was there when they first started launching mandatory mediation in Florida and other states. When they first started mandating mediation, the trial orders or the case management orders, they knew there was going to be some pushback by the lawyers in the 1980s, late 70s, early 80s. And so rather than make mediation sort of the first thing people did, they put mediation requirement at the end of the discovery period. In other words, you ladies can do your normal lawyer thing for a period of weeks and months, but at the end there, toward get closer to trial, go ahead and have a mediation. It was a way of sort of deflecting the early objectors. It wasn't because late mediations are better than early mediations. It wasn't because there was any statistical data that said you should mediate, after you spent 90% of your litigation budget. There wasn't any thinking like that. The only thinking that was going on is we think that some of the lawyers might view this mediation thing as kind of, I don't know, unlawyerly and look at it with a jaundiced eye. And so to deflect the early objectors, it was a psychological ploy, putting the mediation at the end of the discovery period on the eve of trial. So, and that, unfortunately, that sort of mechanism, that sort of thinking that results in the discovery, in the mediation deadline being at the end of the discovery period or at the end of the process, that's still in place today. I can pull up a case management order in virtually any federal court in the United States, and I know when the mediation deadline is going to be, and I guarantee it won't be within the first 90 to 120 days after joinder of the parties. It'll be 30 days before discovery ends, or 60 days before the pretrial conference, or something at the back end. It's bad. It's dumb. It's just dumb. But it's one of those unexamined habit custom things that we as mediators have to deal with. And I tell you, set a second mediation, get an early mediation, give your client a chance to settle the case early. Look, the client can hardly be made to complain about the bills if they were given a chance to settle the case, right? I mean, you had a chance to get this thing put to bed. Now, okay, you didn't. Now, you're going to get some fee therapy, we used to call it. All right, so let's talk about attendance briefly. Man, this is your chance to build a bond with a client that you're not going to have in other settings. So think about who needs to be there. Sometimes when you're in the middle of litigation, you're dealing with an in-house counsel, or you're dealing with a litigation manager, risk manager, whoever it might be, someone kind of middle management. But when you come to mediation, depending on the size of the organization, depending on how it's structured, you want the chief, you want the head, you want someone who's the leader of the organization, or someone who definitely speaks and is the face of the organization. And again, it's client specific, but sometimes the litigation manager is not the best representative for mediation. So what I would do, and I represent a lot of small to mid-cap businesses, I might have an in-house counsel that I was reporting to, but when mediation came, like I was working on a trademark case, well, if the trademarks of the business are in dispute or in play, I'm going to want the owner of the business there, because we might be talking about making changes to our marks and logos, and that's not something in-house counsel is going to make a decision over. That's the client's call. That's the owner's call. That's the business owner's call. That's the president's call. So I always make sure to have the right person there. It's not always the litigation rep. Make sure if you're doing it by Zoom, that your audio and video is top notch. I wrote an article on this called "The Convention of the Witch and the Princess," which you can Google and look up. But very important that your audio and visual be top notch, because there are subconscious adverse consequences to your client if they're dimly lit, if they do not appear well, if they make a bad appearance physically, they don't look good on screen for whatever reason. That does not inure to your benefit. That's detrimental. So check the Zoom feed, check the audio, the visual of your client. Unless your client's in your office, your client's remote, appearing somewhere else in their office, make sure you got it right. I actually had one case where a guy owned a convenience store, and he was working behind the counter trying to attend mediation from behind the counter of it's like a 7-Eleven. I'm not kidding you. I said, no, that's not going to work. You're going to have to go someplace else. So he goes and he takes his phone and he, sequesters himself back in some little storage, room in the back of the 7-Eleven. Case didn't settle. Shocker. Case didn't settle. So make sure if your client's appearing by Zoom, you know exactly where they're going to be, and you better have your paralegal or somebody check the audio and visual feed, because if you can't fix those problems on the day of mediation. And it happens to me on more than one occasion where I've had this sort of silly problem. Let's talk about attendance rules. In most jurisdictions, the court thinks in most jurisdictions, the court thinks that mediation is limited to the parties and their attorneys, but it's not true. In a lot of places, you can bring anybody you want to. They're bound by confidentiality. You can bring an expert, you can bring a family member, you can bring an accountant, you can bring an advisor. It's not limited to the parties. It never was, unless the law specifically says it's limited to the parties. Normally it talks about participants. mediation participants. So as long as they agree to be bound by confidentiality, they can participate in the mediation. So practice habit number one, if you're listening to this, is you call the other side and you say, here's who I'm bringing, who are you bringing? And you get the list ahead of time. Because what you don't want is the classic 9 a.m. on Monday morning, and somebody shows up and they go, who is this? Oh, this is our CPA. He's going to be here to help us. No, we don't want him there. Well, why don't you want it? Well, we just don't like it. We're not going to have these kind of conversations on Monday morning, because you're going to call the other side in advance, and then you're going to say who you're bringing. And then if you don't want the other, if there's somebody you don't want come, you got to have a pretty compelling reason for them not to attend, because rules of self-determination say I can bring whoever I want to, right? The mediator doesn't control attendance. I don't police attendance. You have to work that out amongst yourselves. And if you can't work it out, you got to petition the court. You got to file a motion. But you can't. But the argument, if you go up and you say, I don't want that fellow or that lady there because they're not a party, that's not the right argument. That should, if you're in a thoughtful jurisdiction, that argument won't fly. You can bring whoever you want to. That's why we have self-determination. That's the touchstone of all mediation, self-determination. Well, if you say I can't bring somebody there to help me make this decision, then you're thwarting the process. So you got to let them attend. Now the mediator will police the guest to the mediation process, and if they become a disruptor, then I have ways of dealing with that problem, but I don't determine who comes and who doesn't come. Okay, but the key is, from a practice standpoint, one of the 15 things I'm going to urge you to do in advance, you're going to have a checklist, and I have that for you, by the way. I have a checklist on my website. If you go to henryadr.com, there's a checklist. There's 15 things you have to be doing before you go to mediation, but nobody gives you a checklist. There aren't any checklists. They don't exist. I invented one. I just invented one over 30 years of time. And so you can use my checklist. And this is one of the things you do before mediation, is you call the other side or email the other side and find out who they're bringing and who you're bringing. Because sometimes they don't bring the right person, right? They don't have enough authority. They don't have the right authority. And you don't want to mediate unless they have proper authority. So you make a simple phone call, you build a phone call. So a lot of times there's some billing antecedent to mediation that gets missed that lawyers don't do. And then it becomes a problem at mediation that could have been fixed. So if you don't have key decision makers, reschedule the mediation. That's the long and the short of it. Okay. Special considerations with multiple defendants. Boy, we could do an hour and a half on this. So my background, big chunk of my career, I would do aviation cases, construction cases, some medical malpractice, multiple defendants, multiple law firms, and invariably, the hardest part of getting those cases resolved was the intra-defendant squabbling, the quibbling over, well, how much is each of us going to kick in? What's the pro rata share of the settlement going to be? We got to get to $1 million, and we're arguing about who's in for how much. So the intra-defendant haggling is often the biggest impediment to resolving these cases. It's not the plaintiff. There's a number the plaintiff will take and go away. But now, as a mediator, the biggest problem I have is in the defense camp, because they don't have their act together. And the reason they don't have their act together is because what isn't that they didn't do? Yes. What's the thing that they didn't do before mediation that would have been so easy to do? They didn't talk to each other. They didn't talk to each other. They didn't have any pre-mediation defense powwow about, okay, contractor, architect, sub. Okay, we're in dispute. We're in a lawsuit with the owner. Okay, who's in for what percentage, and what do we think those percentages should be? Because if somebody is grossly underestimating their exposure and hence their willingness to contribute to the settlement pot, I'd rather know that a couple of weeks before mediation than come in on the day of mediation and find out this subcontractor who has insurance he and his carrier are taking a no-pay position. I sure need to know that well before the mediation so I can do something about it. It doesn't do me any good to be surprised. You should not be surprised at people's positions at mediation in a multi-defendant case. If you are surprised about their position and how they're negotiating and what percentage of the deal they're in for, if all that is a big surprise to you, you screwed up and you didn't prepare correctly. But it happens all the time. And the reason it happens all the time is the same reason everything else happens in mediation, because there isn't any rule that tells you to do it. See, in the trial process, there's a multitude of rules. There's rules for everything. There's rules when you got to file this motion and this response, and there's rules for procedure, and there's rules of evidence, and there's rules of ethics. There's a multitude of rules, all of which tells you what you should do and when you should do it. And mediation, we don't have any of those. So all the things that we do, that we should do, it has to be self-imposed. It has to be self-created. It's not going to be imprinted upon us by the court system. We have to generate our own set of internal operating procedures as we lead up to mediation, because no one's going to give us those. They don't exist. Unless you read my articles or you look at my checklist and you go to my website, in which case that material's there. I'll tell you what you need to do in advance and when you should do it, those sorts of things. So they don't meet in advance, and so they don't know what the percentage allocation is going to be. And so we spend the first 4 or 5 hours in mediation where the plaintiff's made a demand, and now I can't get an offer out of the defense camp because they haven't spent any time talking amongst themselves about what their proportional shares ought to be. And if somebody's wildly out of whack in terms of what their exposure should be, we can't really do anything about it on the day of mediation. Can't really educate them. We can't really move the needle very much. So it's very important that you have pre-mediation caucuses if there are unrelated defendants involved in a case, and carriers as well. And I know that doesn't happen because when I was a lawyer for 30 years, nobody called me in advance of mediation and said, Henry, let's have a meeting, you, me, and Smith and Jones and the other defense lawyers, and talk about what we think it's going to take to settle this case and how we think what the architecture, what the framework of this deal might look like. That'd be a pretty useful conversation. And by the way, it's billable. And by the way, it shows your client that you're thinking ahead of time. You're thinking about the problem. You're thinking about the process. And you're billing it. That's the thing that drives me crazy. See, you're costing yourself money and you're doing your client a disservice at the same time. It's a double whammy. It's bad to not prepare. It's bad not to bill. It's bad not to get consensus before mediation starts. All those things are bad. But we do that because nobody's ever told us to do it differently. Because you probably learned to mediate, like I learned to mediate, from some senior lawyer in my firm. So my practice habits for the first 10 years weren't any better or different than the person that I learned from. Well, they weren't any great mediation advocate. They were just doing the normal thing. It wasn't until months and years later that I started to figure out and connect the dots that we're really not doing a very good job of preparing for mediation in the way that I'd like to. So if there's multiple defendants, you should be able to forecast what the opening defense offer looks like. Okay, we're going to come out of the box on this. It's a catastrophic injury case. We're going to come out of the box with a $300,000 offer, and I can comfortably predict, or something like that. And I can comfortably predict that my client's going to be in for about half, and we're going to get contribution from the other defense for the other half. And that's sort of the framework that I can see shaping up and I can live with, right? The other thing you got to be mindful of is coverage counsel. And I want to spend a couple of minutes just talking about coverage counsel. So when we say coverage counsel, we mean the insurance carrier has hired a lawyer to represent its interests, a lawyer separate from the lawyer hired to represent the insured, right? So the insurance coverage counsel is there because there is a problem with coverage typically. There may be an exclusion. There may be something going on with the policy that the insured violated. Maybe the insured made a misrepresentation on the application and the carrier thinks maybe they're going to avoid coverage or there's an exclusion or whatever the problem is. And sometimes the carriers will bring insurance coverage counsel to the mediation for a variety of different reasons. Even if there's not any pending coverage litigation, they sometimes bring coverage counsel when there's a serious coverage problem, partly to educate the plaintiff on what the coverage limitations are so they can hopefully leverage a better settlement. Important you understand if you're defending a case and your client is insured, maybe under reservation of rights, and coverage counsel is coming to the mediation, I want to be very clear about what that coverage counsel is going to say, what they're going to do, and where they're going to sit. Because I might not want them in the opening session. If they are in the opening session, we're going to talk about what they're going to say, because sometimes they can help me. They tell the plaintiff's attorney there's serious coverage problems, nudge, nudge, wink, wink. I'm okay with that because that might help me leverage a better number and get my client out of the case. But I had a case where the insurance coverage counsel showed up I think I was representing an insurance agent, and the carrier, the E&O carrier for the agent, hired coverage counsel, and coverage counsel shows up at mediation in a case involving a lot of credibility determinations about conversations between the agent and the policyholder over what the policyholder wanted in the policy. And coverage counsel shows up at mediation in the opening session and says that, well, we're going to file a deck action and rescind coverage because the insured, my agent, my client, committed a material misrepresentation on the application. Now, why in God's name would you tell that to the plaintiff's attorney? How does that make it easier for me to settle a case? You just called my integrity of my client into question. That just makes my life so much more difficult. But I didn't know at the time, I was a young lawyer, I didn't think to ask, well, what's that guy going to say when he shows up? And do I care about what he says? And it turns out I do. So talk to the coverage counsel in advance. And also think about it as there are non-parties that you need to bring into the mediation to get a comprehensive deal. Sometimes you got to bring in third parties because they're necessary for a complete deal, particularly if it's like maybe it's a real estate problem, maybe it's an easement problem, maybe it's a case involving a governmental municipality or a government agency that needs to be brought into the mediation to get complete deal. Be mindful of that. And call the mediator in advance. Make the mediator your friend. You want the mediator to see you as a cheerleader for the deal, as the person who's trying to put a deal together. And so the mediators see that, they know that. I mean, mediators are just like ordinary folk. If you're trying to help me, I'm going to like you and I'm going to want to work for you. If you're an impediment to the process and you're being obstreperous during the opening and you're saying a bunch of incendiary things and you're not going to be my friend and I'm not going to want to work as hard for you. It's just basic psychology. So think about making the mediator your friend. That's kind of important. All right, let's take a quick break for 3 or 4 minutes and then we'll come back and finish this up. Okay, welcome back. Let's talk about another thing we need to do before we get into mediation. And this is another excellent opportunity to bond with the client, communicate with the client, and that's the drafting of a pre-mediation position statement. Uh, a lot of times the courts will say you need to send a position statement or a summary of the case to the mediator, a week before the mediation or something like that. But nobody shares their position statements, which I never understood, because this is your opportunity to talk directly to the other side unfiltered. You don't get this opportunity anywhere else in the litigation system. So I would sit down and I would write a letter as if I was writing to the other side. Typically I was a defendant. I might be a condominium association, or it might be a doctor or accountant or lawyer, whoever I was representing, a hospital or a hotel, whatever it was. I would write a letter to the claimant. Now, the letter's addressed, of course, to the claimant's attorney, but I would write the letter as if I was speaking to the claimant, because this is my opportunity to educate them. And what I'm trying to do is outline some themes, some concepts, some themes that I'm going to hark back on during the mediation process, and that the mediator is also going to repeat and emphasize. And these themes, of course, depend on the facts of the case, but it might be liability, it might be causation, it might be that damages are speculative, you can't prove your lost profits, it might be that there's comparative negligence, it might be a handful of different things. It might be that there was, if it's a products case, maybe there was some intermediate, some causation problems because someone had tampered with the product, or someone had altered the product, or something like that. Could be anything. Also be time, how long the litigation process takes. Somebody told me early in my career, and they said, David, the great thing about being a defendant is, it doesn't matter how bad your case is. You can have bad liability, bad facts, but you have the checkbook. You decide when the check gets cut. And I had a plaintiff's attorney tell me one thing. He said, David said, time is the plaintiff's kryptonite. And I always use that. Whenever I have a hard case, I know it's going to be difficult to settle. I don't have a lot to talk about. I may have clear liability. I may have some bad problems, but I always have the element of time. Time. People don't like to wait. People do not like deferred gratification. People want to get paid. So if you're a defendant, you always have that. And so the concept of how long it's going to take is something you can introduce in the mediation statement. And you can create some doubt and not too much fear. I don't use fear and intimidation, because they have their own lawyer. Or I don't argue about summary judgment in mediation, because no plaintiff, no lay plaintiff thinks that summary judgment is going to get entered against them. A, they don't even know what that is. But B, they don't understand why it would happen, because their lawyers told them they have a case. So arguing about summary judgment in mediation, to me, is just kind of silly. It's just not effective. So arguing the law, not effective. Tell them why they need to settle the case now and why it's to their advantage to make a deal. Explain to them why it's helpful if they make a deal now with you rather than wait. And say it in a cordial, easy to read tone, and send that out, and then send a copy to the mediator. And then the mediator has a little script that they can continue to use throughout the day. And the first time they hear it, they may not believe it, they may not buy it, they may not accept it. That's okay. That's what the mediation process is for. The mediation process is like, it's like marinating a tough piece of meat. I'm from Iowa, so we do a lot of we use a lot of beef and meat analogies. So if you're vegetarian, I'll try to come up with a better metaphor. But yeah, you got to marinate it. So what happens in mediation is they get introduced these concepts, these ideas. Their expectations get kneaded, get manipulated, get altered ultimately to the place where they're in a position to take a deal. And that takes time for all that to happen. That's okay. And so we're introducing themes we're going to repeat. And the mediation statement, drafting a well-written mediation statement, is very useful, because for one thing, and I know this to be the case, is that plaintiff's attorneys, particularly if they're contingency fee plaintiff's attorneys, they don't get paid to communicate with their clients. They don't write update letters. They don't write status reports. They don't write memos to the client about every little thing that happens. So the client's knowledge, particularly if it's a traditional bodily injury contingency fee liability case, the client only knows what the lawyer told him at the beginning of the case, and there's been very little interim reporting, very little in the way of modifying or adapting to the vagaries of the lawsuit, and their expectations may have been formulated very early in the life of the case, and now the case is very different than the way it came in because the plaintiff got better. The plaintiff doesn't have a big wage claim. The plaintiff doesn't have permanent problem with their legs or their feet. They're walking fine. So the case when it came in looked like a 7-figure case, and now it's a low 6-figure case. And the client hasn't been told that because the plaintiff's attorneys, if they're contingency fee plaintiff's attorneys, they don't get paid to write. And so you have to begin to modify the client's expectations and manage those expectations. And the mediation statement is one important piece that allows you to do that. And if you're on the other side, if you're a plaintiff, by gosh, you definitely want the opportunity to talk directly to the defendant client, because you can't be sure that the defense lawyer is an accurate reporter of what is really taking place and what the real exposure is. Particularly if it's a young lawyer handling the case, they may not, they historically will undervalue the case. They have optimism bias. They have optimism bias. And so they shade the facts. They don't report the ugly. They report the not so great. Okay, they don't tell the client sometimes the unvarnished truth, which is your conduct was reprehensible, you're fixing to get whacked by the jury for a whole lot of money, and there aren't any really good defenses. You don't see those kinds of statements being made in suit reports. It's all kind of postured and synthesized and homogenized, and I mean, a plaintiff's attorney can do the heavy lifting for you. Let them send your client. You should solicit a pre-mediation statement from the plaintiff's attorney. So you, as the defense attorney, don't have to be the bad guy and beat up on your client. You can say, this is what he's going to say when we show up at mediation. This is what you're going to hear. I've told you something like this, but this is what the plaintiff's going to say. And the plaintiff's attorney does the same thing with the statement from the defense. That mediation statement is very useful to the plaintiff's attorney in helping him or her get client control and manage client expectations, particularly if those expectations need to be managed, right? So you're doing yourself and your client a huge disservice if you don't send a mediation statement and you don't send it to the other side. Sending it to the mediator is just not enough. You're trying to convince the other side to make a deal with you. You've got to start talking to them before the mediation, and the way you talk to them before the mediation is to send them a mediation statement, which again is another billable activity which you're not taking advantage of. So you're costing you and your law firm money, and you're hurting the mediation process. You're hampering my ability as a mediator to get a deal done because you won't send the mediation statement to the other side. The court order will say to send the position statement to the mediator, but it never says to send it to the other side, and it drives me crazy. And I've been talking about this problem for 20 years, and I can't get judges to change. I can't. I guess they don't. I guess I'm not ruler king. I can't get them to change. It's incredibly, if you get the sense that I'm frustrated, you're right, because I spend a lot of time in articles and bar journals and in bar association meetings trying to move the practice to a higher level, to get to a more evolved state of being here. All right, let's talk about what else you want. What else can we talk about? Okay, so we talked about preparing the mediation summary. Don't do it 2 days before the mediation. You're going to have to send it 2 or 3 weeks before the mediation, because you got to let it sit in the camp. If you're a plaintiff's attorney and you're asking for a big number in the pre-mediation summary, that's got to percolate in the system. That summary's got to go up to the claims person or the in-house counsel, and then to the ultimate decision makers, and maybe there's a board of directors or something like that that's got to get authority to get the money up on the file, and that takes time. And if you send it 2 days before, it's suboptimal. It's not great. It doesn't do much good. I did a seminar a long time ago I called "Big Bombs Need a Long Fuse." Right. Big bombs need a long fuse. If you're going to be asking for a whole heap of money at mediation, you got to get that thing rolling well in advance. That's going to take a long time to get a snowball going that big in the defense camp. If you're meeting with the client and you're the plaintiff, don't get stuck on a number. Talk about a range. Don't get stuck on a number, because then you're going to set a level of expectation you're not going to be able to meet. And then the other thing I'd like to mention to folks is never confuse business savvy with the ability to handicap litigation. And this is a mistake that I made early in my career. I used to represent, I was in an IP firm. We dealt with a lot of really smart entrepreneurs, very ingenious people, very clever people, very creative people, very high functioning people, and some people were very successful in their businesses. Could be doctors, could be investors, could be real estate tycoons. I mean, very successful people I've defended and represented in some capacity. And what I came to realize is they don't know anything about litigation unless they've been a frequent flyer themselves. They don't know anything about how to handicap litigation. They don't understand how to assess litigation risk. They don't know you have to factor in the likelihood, the expert testimony, the venue, the jury. I mean, all the things that go into sort of the calculus of the case. How good our witnesses are, how much they like the plaintiff, or how much they like my client, or how much, all those things that go into the assessing what do we think is a good number on this case. They don't have any ability to do that. It's not in their skill set. Just because they're savvy in business, just because they're uber successful business people, doesn't translate into the ability to predict litigated outcomes or to handicap the litigation. They think that they can because they've been very successful people their entire lives. They're very successful people. They're top of the food chain. They're board certified, pediatric neurologists. That's a pretty smart cookie, right? They don't know anything about going to trial or what the jury might do, or how long it's going to take, and how much it's going to cost, and what the potential exposure is. They think they're going to win. Right. So their business acumen and their business savvy and their professional success doesn't translate into clairvoyance. And oftentimes they're not at all clued in to what their potential exposure is going to be. So don't let them bully you into thinking this case is better than it is, just because they think it is or they want it to be. You got to be a truth teller, and you sometimes got to deliver the sour message, right? You're not going to win this case. This is not a case we're going to win. You're going to lose this, and they're going to not like that because they're not used to losing. They're not used to capitulating. They're not used to making deals with enemies. That's what they have to do. They have to make a deal with the enemy, and they're not going to like that. And that's when that's when you really start to show whether you're just a trial lawyer, warrior, kind of mindless, spear chucking warrior advocate, or whether you really have the skill set. If you can manage that and talk the client through that and get them to come out the other side and recognize that a settlement is going to be much better for them and cheaper for them and less hassle for them, and get them back to doing what they like to do and what they should be doing, which is not looking back in history and trying to, frame the past events in some sort of, legal factual framework for the jury to consider. That's not a good use of their time. And when you can sell them on that, then you're really adding value to the relationship. The other thing I always tell you to do is send out what is a mediation memo. I developed a one-size-fits-all, what is a mediation memo? It's on my website, henryadr.com. Go ahead and steal it. When I was in private practice, I kept it as confidential and proprietary, but now I'm not practicing anymore. You have it, cut and paste it, put it on your letterhead, pretend like you wrote it, bill it out, whatever you want to do. You're fine to use it, but send out what is a mediation memo? Don't assume that your client knows. I had relatives of mine the other day when I first married into a family later in life, and some of my relatives were very successful people on my wife's side, and I said I'm a mediator, and they go, oh, and they started telling me a little story, and clearly what they were talking about was arbitration. These were very smart, intelligent, highly educated people. Didn't know the difference between mediation and arbitration. So don't assume that the client understands what the mediation process is going to look like, and what is a mediation memo is a really good memo to use and send out in every situation for the client. Okay, we're coming around third base here, and we're heading for home. Things to talk, all the things to talk about before the mediation starts: how long it's going to last, what they can say, what they can't say. Know that they can talk they can talk to you outside the earshot of the mediator. All those kinds of things you want to walk through, and it'll be in that what is a mediation memo. But understand they can hurt themselves in the mediation process if they're not careful about what they say in front of the mediator. So you'll tell them that we're going to be talking together for a while, and then we'll bring the mediator in when we want to convey a number, but we're not going to spend a lot of time talking in front of the mediator. Usually not a good idea. I like it when the clients talk in front of me because it gives me information I can use, but good advocates know that they should shield their client from the mediator most of the day, for a better part of the day. Okay. What else you want to talk about? We talked about their role. We can talk about, real quickly on the insured, if you represent an insured defendant, let me just do 2 minutes on this. I think we're good on time. Let me just do 2 minutes on this. First of all, in some jurisdictions, it's becoming more common to excuse the insured defendant from the mediation because the carrier and their carrier rep's going to be there. The claims adjuster is going to be there and they have the checkbook. So technically you don't really need the insured. And that's true about 99% of the time, but there's a small percentage of cases where there's a problem because the defendant might be having to agree to some non-economic terms, or there may be some things in the agreement that the defendant's going to want to really look at before it gets done. So you need to think about very carefully before you excuse a defendant from mediation, an insured defendant. I don't recommend you do that, but it does. I know it does happen. It only becomes a problem if you don't settle the case and then the case gets out of control and then the insured says, well, if I'd been at the mediation, I would have urged for settlement. And now we look at this problem we're staring at now where I've got exposure in excess of the policy limits. And I didn't know that my carrier had a chance to settle within the coverage limit at the mediation. My lawyer didn't tell me, blah, blah, blah. It becomes a big hot mess. So if there's coverage problems, if there's settlement control issues, if there's a settlement control clause, typically occurs like in a professional liability policy where it will say the carrier can't settle the claim without the consent of the insured. It's common in legal malpractice, some accounting policies, some doctor's policies. There's also a hammer clause that says, however, if the carrier wants to settle, but you nix the settlement, you do not consent to settlement, there's a hammer clause that says, oh, by the way, if you do that, and you say you're not going to settle a case that the carrier wants to settle, then you could be liable for some or all of the attorney's fees and any exposure above the settlement amount. The hammer clauses differ in language, but the gist of it is you're going to become your own reinsurer if you don't consent to a settlement that the carrier wants. That's called a hammer clause. Make sure you understand what coverage counsel is going to say if they're coming to the mediation, and make sure your insured knows before mediation if they're going to be asked to contribute to the settlement. If the carrier's position is that there are serious coverage problems and some of the damages being claimed are not covered damages and they're going to be asked to make a settlement contribution, you as a lawyer need to be very clear with the carrier about that and ask the carrier, are you asking my policyholder to make a contribution, yes or no? And then there's going to be a bit of a tussle there for sure, but you need to have a heads up on that because you don't want to get into mediation and have the carrier for the first time say, oh, and by the way, well, we're in for the first, we'll go 50-50 with the policyholder. What? Didn't see that coming. So those are the kind of conversations you definitely got to get out there in advance, because it may be that if you're insurance defense counsel, they need to get personal counsel involved. And that's a conversation you can't have on the eve of mediation. You got to have that days and weeks in advance with the carrier if the insured's going to be asked to contribute. Pretty gosh darn important at the end of the day. Okay, real quickly on opening statements. Boy, we could do an hour on opening statements in joint session. This is when one of those critical times when your conduct's going to be carefully scrutinized by your client. So you better have a plan going into the opening session about what you're going to say. And you need to look good. This is your opening statement in the mediation. You got to impress your client, but you also got to impress opposing counsel on the other side. Because this is one of the few times in mediation where you're going to be seen, because later on during the mediation, you're going to be in your breakout room. They're not going to see you anymore. So you're going to get 15, 20 minutes in front of the other side. Then you're probably not going to see them for the rest of the day. So you need to impress them. You need to have a plan. You need to have 2 or 3 bullet points scripted and know what you're going to say. But I'll give you this tip as well. You got to be prepared to chuck all that. Because sometimes it's like oral argument on appeal. You've got your points and things you want to argue, but then you get a strange question from the bench, and you got to deal with the question from the bench. Sometimes the script, the idea, the bullet points that you wanted to get to in the opening session don't make sense anymore. You can't be talking about liability issues. You got a widow who's crying her eyes out and talking about how her husband died and how her husband was comparatively negligent and how he's the primary cause of this accident. That's not going to fly. That's not the conversation that needs to take place. So there's preparing, there's, I call it mini scripting, having a pretty good idea of what you want to say, but being able to flip on a dime if it doesn't look right, doesn't feel right. And that's a hard thing. But I don't know how to say it any more specifically than that. Be prepared, and then be prepared to chuck what you just prepared if it's not going to work. Sometimes I've said nothing. I've come in with sometimes I say, as defense in a bad case, this is a horrible situation. Nobody wants to be here. We want a deal. We want to end this. We'd like to come up with a resolution. We're going to work really hard to see if that happens. We may not agree on the ultimate number, but I want you to know that we've taken your case seriously. It's been evaluated not by just the people in this room, but by other people who have looked at this. And you have our full attention. That's all sometimes you need to say. I don't got your case. You don't have a lot to talk about. And that works. I had a plaintiff's attorney tell me one time, I said, David, I was a mediator, and he said, I want you to compliment David, go in and tell the defense attorney on the next break how much I appreciated his opening statement, because I thought he was going to rip my client up and down, and he didn't. And he was very respectful and very diplomatic. And it makes my life as plaintiff's attorney so much easier because I don't have to peel my client off the ceiling. Right. You see how smart that is? This is not closing argument in front of a jury. This is not a positional debate. You are trying to make a deal with the enemy. Why would you upset them? Why would you get angry? What is there to get angry about? We're here to make a deal. We're here to negotiate a resolution. We both want a resolution. We're on the same team in that sense. We're on team settlement. We want different things out of the settlement, but we all want resolution. So why are you being angry? Why are you upsetting the other side? Why are you making it more difficult to get to a deal? People don't want to make deals in a high stress, high anxiety, highly contentious environment. That's not conducive to deal making. Every deal on its core level requires a modicum of faith, good faith, like a little leap of faith, because you have to have belief that the deal will be followed through, that they will live up to the terms of the deal. So no matter how contentious the parties are, when they make a deal, it's like a little leap of faith that I trust you just enough to live up to this deal. And if you're operating in a low trust environment, you don't want to put gasoline on the fire. You want to create a situation that has the appearance of trust, the appearance of good faith, the appearance of goodwill. You want those vibes floating across the table, even if you have a very contradictory agenda. You want the sense that we were joined. Our agenda has commonality to it, that we want a deal. So don't dispense with opening. I know there's some jurisdictions where they dispense with opening session, and I talk to the mediators and the lawyers in those jurisdictions that dispense with opening. I go, why do you do that? And they go, well, basically it comes down to we don't trust the other side to behave properly. Like, you're such bad lawyer advocates in mediation that you can't be trusted to conduct yourself with diplomacy and decorum and be polite. And so we don't do the opening sessions. Wow. I mean, we could spend weeks sort of unpacking all that, but if this is my chance to talk directly to the claimant or directly to the defendant and tell them things that their lawyer may not have told them, why would I want to give up that opportunity? It's a golden opportunity to educate the other side and make an impression. And particularly if I have a corporate client, I can humanize my corporate client. We're real people here. We're not these big bad boogeymen that you read about. We're not all these awful individuals. We're normal people, and we root for the Red Sox just like you do. We root for the Buccaneers on Sundays just like you do. Right. Right. So those are all really important things that we can do during the opening session if you dispense with opening. Now, you don't get that. Now, I will dispense with opening if it's a really nasty case. If it's a molestation case, or it's some kind of horrific fact pattern, maybe it's really nasty sexual assault or something like that. Yeah, I'll dispense with opening, but that's a pretty rare event. That's pretty rare. So that's another conversation you want to have with the opposing counsel is, we're going to do joint session, yes or no? Because you don't want to show up on mediation and one side says, well, we're not going to do opening. Well, the other side may have spent a couple hours preparing what they were going to say and thinking about what they were going to say. And they had some things they wanted to say and they wanted to share. And now you cut them off at the knees. That's going to make a very unhappy camper in the other room. Again, you're torpedoing the process at 9 o'clock in the morning because you didn't have a conversation about what the process is going to look like. And you didn't have that conversation because there's nothing in the rule book that tells you to do it. All these things I tell you to do are all self-imposed practice habits. They're self-imposed. It's like a workout and there's no personal trainer. You don't have a personal trainer. No one's coming to your house to tell you what to do. You got to do it yourself. And that's not always easy. It takes a lot of self-discipline. Apologies, I'll say real quickly about that. If you're going to do an apology, and I recommend apologies, make sure you practice what you're going to say, because I don't want an apology needs to come from the client, not from the lawyer. Finally, I want to talk about one more thing, and I want to talk about NDR. If we get stuck and we can't get the case resolved, what do? First thing is get more information. Go back and revisit the facts. Go back and revisit the procedural posture. Go back and talk about how we got here. What is it? Why? Ask this question to the mediator. Why doesn't the other side want to settle? What is driving there? And keep asking the question. You might not get the answer the first time. The mediator might have to go back in the room and get more information. Keep asking the mediator, why is my number not the number? Why do they need another $1 million? What is it I'm missing? Keep asking the same question in different ways, and you're going to get information, or you may not. But you got to keep trying to get more and more information. If people are miles apart, it's probably because there's some facts or information that are not commonly known or shared. Because if you think about it, if you have reasonably competent lawyers, experienced, competent lawyers, and they have access to the same information about the dispute, their evaluation of the dispute for settlement purposes shouldn't be widely disparate. In other words, they shouldn't be miles and miles apart. If they should be able to handicap the case and go, okay, the damages are, past meds of this, future meds of this, pain and suffering, age, This case should go for between $750,000 and $1 million. And the defense lawyer and the plaintiff's lawyer should be within some measure of similarity in terms of their valuation. Defense is going to be a little lower, plaintiff's going to be a little higher, but they should be within gravitational pull of one another. If the defense camp saying this case should resolve for $500,000 and the plaintiff says 2.5, somebody knows something the other side doesn't know, or somebody's operating under a mistake of law or fact or something. There's a fly in the ointment here, because they shouldn't be wildly disparate in terms of handicapping the exposure and the settlement, ultimately the settlement value of the case. It can't be. Somebody knows something that somebody else doesn't know. Somebody doesn't know something that the other side does. And the key in mediation is making sure everybody has access to all the information so they can make an informed decision. So I get stuck as a mediator, I got to start digging. I go, why do you think that way? What is it what are you hanging on? What is the thing that's driving this discussion? What is the assumption or the fact or the piece of evidence or the theory? And you just keep digging and digging and digging and picking and picking and picking. And sometimes it reveals itself and sometimes it doesn't. Sometimes the case just can't settle because there are extraneous problems going on. The client won't settle for whatever reason. The defendant won't settle because it sets a bad example, or it creates a precedent, or it creates a problem with the customers or the downstream distributors or whatever it might be. Sometimes there's ancillary reasons why cases can't settle at that point in time that are outside the four corners of the dispute. And you got to be mindful of that. Some percentage of impasse is outside the four corners of what the lawyer and the mediator can really deal with, right? It could be, I do a lot of family estate cases and wills, estates, and trusts, and there are long-standing family disputes that are churning in the background, and it's impeding liability to get a deal done. It doesn't have anything to do with the four corners of the case. It has everything to do with stuff that's been going on for years and years and years. It's going to take a lot of therapy and a lot of time to get through. So just understand, some cases are just not going to settle. And it took me a while to kind of get my brain around that. But there's a small percentage of cases that just cannot settle on the day of mediation for whatever reason. And if you get stuck in mediation and you're looking for another way to go, let me just I'm sorry, I apologize here, just trying to make sure we get the right page. I want to talk just for a second about neutral driven dispute resolution. So NDR was a thing that was invented by a guy named Rob Christopher in a book called just right how neutral-driven resolution can close the gap in American justice. He wrote this back in 2022. Neutral-driven dispute resolution is an ancillary proceeding for resolving cases where there's not a whole lot in controversy, and the parties are looking for speed, efficiency, a principled, reasoned decision, but they don't want to spend the time and effort it's going to take to go slog through a long piece of litigation where you're going to spend hundreds of thousands of dollars. Can't do it. So in a small to mid-cap dispute, or where you want confidentiality, or where you have maybe you have an existing, customer vendor relationship or a manufacturer distributor relationship, you don't want to air your dirty laundry in court, or you need to do it quickly, and you want confidentiality, and you don't have a ton of money at stake, so it doesn't warrant the expenditure of tens of thousands or hundreds of thousands of dollars in legal bills. You can use an NDR proceeding, a neutral-driven dispute resolution. And what that is a stripped-down form of arbitration, essentially, where the neutral does the work. The lawyers don't do very much work. It's incredibly cost-saving because the lawyers aren't doing all the attendant lawyering things. There isn't motion practice. The discovery gets done by the neutral. The neutral talks to the witnesses. The neutral requests the documents and looks at the documents. The neutral then issues a preliminary opinion, an award essentially, like an arbiter would. And then the lawyers and the clients have an opportunity to comment on that. And they can bring up whatever they want to. It's much less formal than like a AAA arbitration. And it's much cheaper because you hire the neutral for a fixed fee. The neutral and the lawyers get together, they talk about the four corners of the case, they talk about the list of witnesses, whether there's any experts are going to be involved, typically not. These NDR proceedings are better when there's no experts. But you could incorporate an expert, or maybe you have an agreed upon expert or something like that. But you can feed them in. It's a very flexible process. But for a stated sum, a fixed fee, the NDR, the neutral, is going to talk to the witnesses, review the documents, issue a preliminary opinion, and ultimately the parties are going to have an opportunity to comment on that. And they can, like a rehearing sort of thing, like a motion for rehearing. You can ask for reconsideration of whatever it is you want. And then the neutral will issue a revised opinion, or maybe they won't. And that can be subject to another round of commentary. And it could be multiple iterations until they get to a final opinion. And finally, the arbiter, the neutral, says, I've heard it all. I'm comfortable with my ruling. This is my award. And then you go and enforce that award under the arbitration rules. So you just have a private NDR agreement that says, we're going to hire this neutral. They're going to do these things. They're going to issue an award, and the award's going to be enforceable just like any other arbitration award. And this process was invented. It has existed in other forms in the past, but Christopher in his book kind of put it all together and called it NDR, which I think makes a lot of sense. And then he and I co-authored a piece on this for the Florida Bar Journal, which I quote in my materials here, and you can just Google Henry and Christopher neutral-driven dispute resolution, the missing piece of ADR. You can just Google Henry and Christopher and neutral-driven dispute resolution. You'll get that Bar Journal article, and it summarizes it. But it's an excellent option for a category of cases that are too small to ignore, that can't get mediated. There needs to be an adjudication of some sort. There needs to be someone making a decision about who wins and loses, but nobody wants to take the time and money to engage in full-blown litigation for a variety of reasons. And so I think NDR is a really helpful tool in those category of cases. We're talking about mountain controversy, maybe under 250, under 500K. You don't want to spend 100K arguing about a $200,000 problem. And that's the problem with our civil justice system, is the rules of civil procedure in state and federal court don't make any distinction between cases that are worth $100,000 and cases that are worth $2 million. Same rules, same process, same machinery, and we don't have a stripped down form of litigation for small cases. We don't. And Christopher came up with this. This NDR is his fix around that problem, his workaround around that problem. And we have cases that warrant a decision maker and warrant examination of facts and evidence, but we just can't spend the time and the money to use the litigation system, and we don't want to. It's too expensive. And so the savings are tremendous. A case you might spend $100,000 in legal fees, you can have the NDR decided for 10 grand a piece. So the neutral is hired for 20 grand and works over 6 to 8 weeks and comes up with a final binding opinion 6 to 8 weeks later. That's something to think about. I think it's a useful tool. I don't know how quickly this is going to come to be because lawyers are slow to make change, but I think it occupies the same. I think NDR proceedings occupy the same space that mediation did 40 years ago. It was looked at a little suspiciously. Nobody really knew what it was. We didn't know if it was going to work. Why do we have to do that? There was, this sort of knee-jerk, I wouldn't say animosity, but skepticism about the process. And NDR, I think, occupies the same space that mediation does 40 years ago. And it's going to be slow on the uptake because litigators don't like rendering themselves unemployed. Lawyers don't want to turn the client over to a process with which they may be unfamiliar, right? So I don't really know what that is. I don't know why we want to use it. I'm a little hesitant to give up that much power and control. Yeah, you're giving up power and control to a neutral, but your client's also saving 80% of what you would otherwise spend. It's 20% the cost of what you would otherwise spend to get it, and it's faster and it's quicker and there's less hassle. And you get a principled, and you can hire somebody with subject matter expertise. So there's a lot of advantages to it. You're not waiting on 6 or 9 jurors to make up their mind 18 months from now. You're getting a reasoned, thoughtful decision maker, probably someone with some subject matter expertise, to look at the problem and come up with a decision. So I think there's a lot of advantages to NDR proceedings. They're not very well known. Again, this term was only coined by Christopher in 2022, so it's brand spanking new. And I would encourage you to think about NDR proceedings if you get in that situation. Christopher has a whole panel of neutrals. He's based in California, but he's got a panel of neutrals, including me, across the country that you can use depending on where you are. Okay. Concluding comments and the drafting a settlement agreement. A couple things I want to mention on drafting a settlement agreement. At the end of a long day, you could be tired. Check your notes. Some things that you talked about early in the day may get lost in the shake, get lost in the mix. Oh, we talked about as part of this deal that you were going to sign your rights over to this, that, or the other thing. We spent a lot of time talking about money. We forgot about some of the other deal parts. So go back over your notes. Mediators should be doing this too, but take your time at the end of the day. Now, if you can't get everything done, and typically it's the case, you're at 6 o'clock at night, it's a Friday at 6 o'clock, you've been mediating all day, you got the 4 corners of the deal. You have what looks like a deal. Now you got to go write it all up. Well, no one's going to write it all up on Monday night because it's going to take too long, or Friday night. So we do a term sheet. The key to that is understanding when you leave the mediation, either you have a fully enforceable binding deal or you don't. There's no in between. It's like being a little bit pregnant. And I can't tell you how many times I've had problems come, not on my watch, this doesn't happen, but I've been in situations or I got dragged into a situation as a mediator where I'm mediating whether there was a mediated settlement agreement or not. We're mediating whether we had a deal on Friday afternoon. That shouldn't happen. Mediation, the role of mediation is to terminate a litigation, not perpetuate it. You're substituting one dispute for another. If we're having an argument about whether we have a deal or not on Friday, that's bad. That's mediation malpractice. Everybody leaves at 6 o'clock on Friday night knowing either A, we have a deal, and here it is, or B, we think we're going to get to a deal. We're very confident we're going to get to a deal, but it's got to get written up on Monday and Tuesday, and only on Monday and on Tuesday when it gets written up and it gets signed, that's when we have a binding deal. Anything up until that point is not enforceable. It's really important when you leave mediation, you be clear on that. If there's another writing that is contemplated down the road, a full-blown settlement with all the bells and whistles, then you don't have a deal on Friday afternoon. You have an agreement to agree, and those are not enforceable. So be very clear on whether you, and so you bring your draft language, bring your template, bring whatever you want to the mediation as a Word document. And if we can draft it up and smith it up on that evening, great. But if we can't, be very clear when you leave that everybody understands we don't have a deal. Not yet. We're probably going to get there, but we don't have a deal yet. I think that's really important. I don't ever want you to be in that position where you have to argue about whether you made a deal or not. Okay, concluding comments. Plan for 2 mediations, one early, one later in the life of the dispute. Solicit and send, get from the other side a pre-mediation summary and send one to the other side and the mediator. In a multi-defendant case, coordinate conversations with the other defendants and the carriers, if any, well before the mediation starts. Don't do it the day before, not enough time to react to new information. If I've got a defendant who I think should be contributing and they come in with a no pay or low pay position, I got to be able to bang on them for a little while and send them some documents and send them some nasty emails and do what I need to do to move the needle. And I can't do that the day before mediation. So I need to have, if it's a big case, I need to have conversations with my co-defendants well in advance and schedule them. And the other side's not going to do that because they never do, right? Understand you're going to be the trendsetter here. You're going to be changing the practice habits. Your practice habits have to change. If anything out of this seminar you walk away from is that I want you to change the way you approach the mediation for the rest of your natural life. I have modest expectations. You need to change the way you approach and think about mediation forever. It's hugely valuable. It saves countless tens and hundreds of thousands of dollars, months and years of pain and suffering. If you're good at mediation and your clients want you to be good at mediation, they're not going to, CLM did a big study and they said, how do you all pick, and it's like claims liability management. There are a lot of insurance companies and risk managers and things. How do they pick law firms? You know what the #1 survey answer was? Timely reporting and budgeting. They don't pick lawyers based on trial results. They don't. They don't pick lawyers based on trial results. So if you're touting your trial advocacy, you're selling something nobody wants to buy. You're selling, it's like you're selling, it's like you're a chef and you're selling a meal. Oh, it's a special. We have a special tonight. No one's eating that special. They're eating the stuff that's on the menu every day. That's what you have to deliver, right? You're not preaching to the right audience if you're talking about your trial advocacy and your trial skills. That's not how you're going to be judged. That's not how you're going to be evaluated. That's not how you're going to form a client bond that takes you through the tough times and into the future and gets you those long-term 20, 30, 40-year institutional client relationships that every lawyer wants. You're not going to get that from trials because you can't. They're low-frequency events. So hopefully this has been helpful to you and change the way that you think about mediation and conduct yourself. If you get into a jam in a mediation and you're anywhere, call, phone a friend, phone me or phone a friend and ask for help. Sometimes you'll get into a mediation, it'll be weird. Somebody's saying something or doing something and you don't know how to react to it. You don't know if it's unethical. You don't know if it's improper. You don't know if you should terminate the mediation. Phone a friend, phone me, call me. Normally I'll take the call. It happens to me 3 or 4 times during the year. Some other mediator or somebody will call me and I got this situation. I don't know what to do. And sometimes having another pair of eyes on the problem can be useful. You can also subscribe to Mediation Minute on my website. And there's that what is a mediation memo on the website that you can use. And there's a mediation countdown and a timetable on my website, Henry Mediation or henryadr.com. Will get you there. So thank you for attending. Appreciate it. And good luck to you going forward.